Welcome back to the Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we're talking about how you can join the cool kids like Colt and Remington and file for bankruptcy.
These ultra-unique ammunition displays from Ballistic Concepts are the ultimate in gun guy gifts. From tiny to massive, they offer calibers from mild to wild, including things like the classic M855 and 45 ACP, or the massive 950 JDJ and 20mm Vulcan, all handmade right here in the United States. To get 10% off these bad boys, use the code TGC10 over at ballisticdisplays.com.
Earlier this week, Remington reached an agreement with its creditors to file for Chapter 11 bankruptcy. For those of you that missed it, there was a segment on TGC News which revealed Remington was $950 million in debt. That's right. That's 95 times more in debt than Dr. Evil wanted to not destroy the world. Bankruptcy proceedings are not something that are new to the firearms industry. In fact, Colt filed for Chapter 11 bankruptcy just a couple years ago in 2015. As the industry continues to adapt to a market that's not driven by fear, it is possible we may see more companies looking at this option. Because most of us don't put ourselves almost $1 billion in debt, we're going to take a 30,000-foot overview as to what Chapter 11 bankruptcy is. Unlike Chapter 7 bankruptcy, which results in a business closing and its assets being liquidated to pay its debts, Chapter 11 results in the restructuring of a company in order to pay its creditors. Chapter 11 is more commonly used by companies rather than Chapter 7. The proceedings start with the company filing a petition in bankruptcy court, and yeah, that's right, there's a special court for that, along with a listing of assets and liabilities, current income and expenditures, contracts and unexpired leases, and a statement of financial affairs. In essence, the lists are to give the court and creditors an idea of what financial situation the company is in. Probably not good if they're filing for bankruptcy. I've included a link to Colt's petition in the description where you can see what one of those looks like. After that petition is filed, the company becomes known as a debtor in possession, meaning that the company keeps possession and control of its assets while undergoing a reorganization under Chapter 11, without the appointment of a case trustee. Unlike other bankruptcy proceedings, the use of a case trustee in Chapter 11 is the exception rather than the rule. Rather than an outside person managing all of the affairs, as would be the case with a case trustee, the company gets to keep on driving the car with the instructor in the passenger seat. The company is also required to submit a plan of reorganization. It includes an explanation how the company will repay each group of creditors. Like everything legal related, nothing is ever simple. There are different classes of creditors who have varying rights when it comes to debts owed to them. Those who have the same rights as before the plan are known as unimpaired creditors. Those who are left in a different position are known as impaired creditors. The easiest way to describe this is with an example. Say Remington has an agreement with creditor A that they're entitled to 5% of the profits. Under their proposed reorganization plan, they tell creditor A, you're still entitled to that 5%. Creditor A is an unimpaired creditor because nothing changed for them. On the other hand, creditor B was entitled to 10% under their original agreement, but under the proposed reorganization plan, it was reduced to only 5%. Creditor B would be an impaired creditor because their rights were altered in a negative manner. The impaired creditors vote on the plan to either accept or deny it. If accepted by them, the plan is put into action. In the case of Colt, there were 9 different classes of creditors, 4 of which were impaired and entitled to vote on the plan. I've included a link to a case study about Colt's proceedings in the description down below. After a petition is filed, an automatic stay goes into effect, which provides a period of time where judgments, collection activities, foreclosures, and repossessions of property are suspended and may not be pursued by the creditors on any debt or claim that arose before the filing of the bankruptcy petition. Some creditors can actually pursue those activities, but it requires court approval to do so. Think of it like a timeout in sports.
30-second timeout.
The company is able to continue operations, but it's not without having someone watching over them. The U.S. trustee is responsible for overseeing the administration of bankruptcy proceedings. The debtor in possession is responsible for things like accounting for property, examining and objecting to claims filed against it, and filing informational reports as required by the court, like a monthly operating report. The debtor, with the court's approval, can employ lawyers, accountants, or other professional persons to assist the debtor during its bankruptcy case. The U.S. trustee keeps a careful eye on the debtor and monitors for compliance with the reporting requirements and operation of business. A creditors committee is appointed by the U.S. trustee and ordinarily consists of unsecured creditors who hold the 7 largest unsecured claims against the debtor. And an unsecured creditor is an entity or an individual that's owed money which is not backed by collateral. The committee consults with the debtor on the administration of the case, looks at the debtor's conduct and operation of business, and participates in formulating that reorganization plan I mentioned before. The committee is viewed as an important safeguard to the proper management of the business by the debtor. After all, they have a vested interest in seeing it succeed because they're owed money. Once a plan is successfully approved, it generally discharges any debt that was held prior to the petition being filed.
I love it when a plan comes together.
However, new obligations are created under the plan, and the debtor is bound to those provisions. In other words, the repayment of the debts approved by the creditors is now the binding agreement. While bankruptcy sounds like the end of the world, Chapter 11 is a way in which companies can shed debt, come to an agreement with those that they owe money to in order to continue operations, and hopefully emerge a stronger company. However, the restructuring of debt is only a small piece of the puzzle to running a successful business, particularly in an industry where innovation seems to drive sales, or should. Time will tell if Remington survives and ultimately thrives, or continues to flounder. As you probably know, ballots for the NRA Board of Directors are out. In order to make the NRA the organization we deserve, you, the members, need to participate. To learn more about the NRA Board elections, head on over to my website, adamkraut.com. The link is in the description. Sick of bad information finding its way around the internet? Make sure you share this video with your friends. Don't forget to hit that like button, get subscribed, and consider supporting us via the links down in the video description. If you haven't yet, be sure to download the Gun Collective podcast on iTunes. We would love to get your feedback on that. And as always, thanks for watching.
The shirts worn in today's video on the Gun Collective have been provided by Patriot Patch. Closed captions have also been brought to you by Patriot Patch Company. Be sure to click the link in the video description to check out all of their great products, including their cleaning mats.